Good afternoon, ladies and gentlemen, and thank you for joining us on today's LIBN Now Experts Forum. As a reminder to all of our live guests, this session is being recorded. Zoom participants can submit their questions at any time by clicking Q&A on the bottom of your Zoom control bar. Today, we're talking labor and employment law post-pandemic. We are speaking with Avrohom Gefen of Vishnik McGovern Malizios Labor and Employment Law and Commercial Litigation Practices, and Ash Nelavelli of Meltzer Lippy's Labor and Employment Practice Group. Moderating today's discussion is LIBN's editor, Joe Dowd.
Well, good afternoon, and thank you very much to our guests for joining us on LIBN Now Experts Forum. Ash and Avrohom, thank you very much for joining us.
Good afternoon, Joe. Thanks for having me.
And I just want you all to know we're going to go about 30 minutes on this. Labor law is something that is central to our audience because so many of us are employers. So many of us have people who count on us to protect them in the workplace. And there have been significant changes to labor law in 2022. And what I'm hoping you can do is help us in the most direct ways to navigate some of those things. So what are some of the biggest changes forward that we need to know about? And how should we begin to navigate them? I'm going to start with Avrohom. Give me the overview.
Sure. So the first thing is not so much of a change, but rather a continuation of the law that went into effect during the height of the COVID pandemic, which was related to COVID sick pay, which is required for all employees, depending on the size. It could be unpaid or partially paid for a longer period of time, shorter period of time. But many employers and some of my clients are surprised and have been asking whether it's still continuing. And the answer is yes, that these laws are still in effect. And the only thing that's really changing is the length of time that they may have to be in effect for, because that's dependent on periods of required mandatory quarantine or mandatory isolation, depending on whether someone has been in close contact with someone with COVID or whether someone has COVID themselves. One of the interesting things is that you can do it. An employee can have multiple times a year of paid COVID sick leave, up to 3 times per year. One of the things that has changed is that only the first time can be for either the person or a relative who has to quarantine or isolate. The other 2 times can only be for that person's own required isolation, meaning that they actually contracted and are symptomatic with COVID.
Mm-hmm. And a quick follow, Avrohom, because I know this is relevant. Isn't there a reporting requirement? In other words, you don't have to show in some cases that you don't have to go to a doctor to prove that you had COVID from
right.
Right.
Well, this is actually another change in that previously they were required an employee who was seeking to invoke this law to get paid leave or unpaid leave for COVID had to get an order. And there was a relatively easy procedure on the New York State's website where you can get an order from the Commissioner of Health. But now it's permitted to self-attest. And that self-attestation has the same effect as a mandatory order. Okay,
very good. Ash, from your perspective, what are some of the biggest changes going forward, and what does our audience need to know?
Well, picking up on the New York State quarantine leave law that Avrohom talked about, there are opportunities that employees can take advantage of to ensure that they're vaccinated. And the state has provided, New York State has provided vaccine leave or paid time off to obtain vaccines. Employers should be aware that they are required to provide up to 4 hours per vaccine, to the extent that until they are fully vaccinated. So if it's a 2-dose vaccine, they would need to take, they are entitled to at least 8 hours of paid time off. Moving along on the same track, employees are also entitled to time off to recover from vaccines, to the extent that they exhibit, are symptomatic, or they are unwell following the vaccination. They are entitled to take time off, either under state paid sick leave or paid family leave to catch.
Now, Ash, I think the law says 4 hours, right? Once you get the shot, so you're allowed to take 4 hours off and get the shot. What happens if the reaction to that shot lingers for a full day? Is that what we're talking about here? How does that work?
That is correct. So the recovery time following the vaccination itself. So the 4 hours is up to 4 hours. I need to clarify that. So an employee is not entitled to 4 hours to obtain a vaccination if the place that they are going to be vaccinated is down the road from their employer. So, and you can obtain the vaccination during your lunch hour, then you're certainly not entitled to an entire afternoon off. But you do get up to 4 hours to the extent that you do need it. The recovery time is in addition to the 4 hours. That would be the part of the New York State paid sick leave.
And if I can add to that, it's not only applies to the employee for their own vaccination purposes, but for example, if a parent who's an employee is taking their child for a vaccination, they would be entitled to the same 4 hours for that vaccination as well.
That's right.
Have you guys seen, in your experience, problems with this? As an employer myself, I mean, I have a staff of people, right? If they need to take time off to get a vaccine, I go, sure, no problem, because that's something that seems important. Have you encountered issues with this so far, with employers saying, no, I don't want you to do it on your own time? Has there been a lawsuit somewhere? What can you tell me about the problems that this has caused?
So I haven't seen anything in particular with this issue. This is not something new. There's been laws on the books for a while with regard to, let's say, for voting, that employers are required to give certain time off for that. These are not the types of things that employers usually get tripped up over. They're important to know, and sometimes it's kind of obvious, and usually there's a certain modicum of trust between the employer and the employee that they're not going to be abusing it, like Ash touched on. If the clinic is down the block where you're getting the vaccination, then there's no reason to take off for 4 hours. But as far as lawsuits, not really. This is not a big issue from my perspective with regard to compliance with this particular law.
In fact, Joe, to the contrary, employers, in my experience, want to ensure that their employees are vaccinated. So,
Right.
And you have so many laws, especially in the city of New York, where you are required to be vaccinated. So all around, this seems to be a good thing for employers.
Okay.
If I can just touch on that point, one of the big issues that's been in my practice for the last couple months has been the opposite of having employers who would like to get all their employees to be vaccinated, and they're getting pushback from employees for various reasons, whether it's a religious or a claimed religious, or it's a health reason. And it's a tricky road for employers to navigate, to respect their employees' rights, but also to provide a safe workplace, as well as to comply with the law.
Let's talk about religious exemptions for a moment, okay? That's a confusing area for lots of people, right? How do you successfully navigate as an employer, someone who comes to you and says, I have a religious objection to being vaccinated, and you're, let's say, in New York City, and you're required to to be vaccinated. How do you navigate it as a boss? Is the short answer, you got to call a lawyer?
That's always good advice. But the most important thing is to have a dialogue with the person. And the guidelines, the guidance from the EEOC is that there shouldn't be too much of an intensive questioning as to a person's religious sincerity, unless you have obvious reasons that you know, or there's an indication that it's not a legitimate religious request or religious reason that the person is rejecting or not wanting to be vaccinated, then you should grant the exemption. Now, it's important to remember that these exemptions are still have to be that the person can do their job with some sort of an accommodation. So if the person is required to be in person, close contact with other employees, and is requesting a religious exemption, even if it is a sincere religious request, the employer may not be required to grant it, in that the person cannot do their job with an accommodation. You can't say, okay, you can do your job, but you have to work in a different room if they have to work in the same room as other people. There's no accommodation that you can give them that would allow them to do their job duties.
Right. It seems like it's hard. It could get really dicey in certain instances, don't you think, Ash?
It does, certainly does. In fact, we've handled numerous religious accommodation requests or exemption requests in the last few months. And I can tell you, there's very infrequently a straight answer. And there's very few times where you can explore the employee's religious background or religious belief. But the key thing is that the belief be sincerely held. However, I have to say, the city of New York has given us a little bit more of leeway here with this religious accommodation request. In fact, they've put out guidance on this issue. And you can ask more probing questions, slightly more probing questions, I feel, than the state guidance or the EEOC guidance would allow. So I would urge employers to take a look at the New York City guidance on that, and certainly speak to a lawyer to help you guide through this.
Can you give me just a little example of that? That, in other words, the question of sincerity, how would you judge someone's religious sincerity from a little bit of a distance if you weren't a member of his church and or synagogue?
Well, I'm not sure if that's directed towards Ash or towards both of us.
I'll
but I
take
can-
both of you, please.
Yeah, I mean, if Ash, feel free, but in my experience, I mean, I've had just a glaring example where I had a client that one of their employees requested a religious exemption, and they asked me to help to sort of meet with any employees that were requesting these exemptions, to have a dialogue so that they can make a determination. And one of the things that came out during the interview was that the reason why the person objected to vaccinations was because he believed that vaccinations caused autism. And it was almost clear that it was just, he put down religious exemption on his request, but it really wasn't a religious exemption. It was based upon his fear or his belief that it causes autism. So in that case, it was a pretty clear cut. But Ash is correct that it is often dicey and hard to make a determination without going to the person's church and finding out if they really believe or what they don't believe. And it doesn't necessarily have to be an organized religious group that they're part of that is opposed to the vaccines. It could be a personal religious belief, and that would be enough to allow them or at least consider an exemption based upon religion.
Absolutely correct, and I agree 100%. The truth of the matter is, even if the head of the religious organization, so for example, the Pope is pro-vaccine. That does not mean that every Catholic is necessarily pro being vaccinated. And they may obtain a religious exemption to being vaccinated based on their individual religious belief. Even though it might be the head of their religious organization may not share that same view, I suppose.
Well, the Pope has his own opinions on a number of things. His Holiness is famous for that. Let me follow that to a layman, a non-lawyer like myself. Okay, it's very confusing. And you can imagine employers also being very confused. They're going, how is it possible that leaders of a church of 1.1 billion people, in the case of the Roman Catholics, okay, can have his followers, in a sense, the followers of Roman Catholicism? How is it possible that they can object on their own, especially in the United States, where we're supposed to have some kind of separation between church and state? Just seems to me like if you're a New York City firefighter or you're a New York City police officer and cops say, you got to get vaccinated, like the fire department did. You got to get vaccinated. There's no religious exemption for that. Religion shouldn't be a factor in it. How do you respond to the layman and to the lay employer to that question, or that type of question? Avraham, I'm going to give it to you.
Well, with respect to how you respond to that, is that there's a Constitution in the United States which gives certain protections. One of them is protection of freedom of religion. So that's what all this is based upon. The religious exemptions are based upon the constitutional rights to freedom of religion, to freedom to practice your chosen religion. And I think that that's very important for employees to remember, because it's going to be a question of the employer either rejecting or not rejecting a person's very personal belief. And not only does it affect how they're going to operate their business, but it could affect the long-term relationship between the employer and the employee. It could affect the morale between other employees if certain employees are granted exemptions and other employees are not granted the exemptions. All this is very important to keep in mind for the employers. And I think that on the flip side, it's kind of interesting in that some employers see this as an opportunity because they don't want to offend or hurt their employees, and they're not that concerned with having employees vaccinated. And this gives them a chance or an opportunity to say, well, I followed the law. I required my employees to be vaccinated, but I also followed the law by allowing certain employees who requested it, a religious exemption, to have that exemption, and sort of like a balance, and that they can not only answer to the government, but they can answer to their other employees that they have to respect, and they respect everybody's religion.
Okay. Before we leave this subject, I want to just touch on family leave. Can you guys enlighten me and my audience on that, please? What's the status of family leave, and how is that affected by the changes?
So the paid family leave laws have been in effect for a while now, and they are related sort of to this issue, because for employers who are below a certain size, although they are required to give certain leave for COVID related illnesses to their employees, they're not required to pay for that. However, if the quarantine of the employee or the isolation of the employee extends past whatever they are required to, for example, if you have an employer who has 50 employees with revenue above $1 million, they're required to give, let's say, 5 paid days of COVID sick leave. Now, what if the person has isolation that they're required to isolate for 14 days? That employee, can apply for paid family leave to make up for the rest of the time that they have to quarantine or isolate. And again, the paid family leave is now, the amount is extended. The benefit is now over $1,000 per week. It's going to be adjusted periodically based upon the percentage of the average salary for employees in New York State.
That is very helpful. What I'd like to then move on to is the New York State HEROES Act. We also want to talk about how certain employers have to have processes in place in the workplace. Can you discuss that, Ash, and give our audience an overview?
Sure. So the New York HERO Act is essentially requires employers to adopt a airborne disease prevention plan. The New York State Department of Labor has multiple industry-specific model plans that employers can take advantage of, review it, adopt it, and distribute it to the employees. So there were, in fact, I can give you exact dates. I believe it was mid-July of last year when the state put out the model plans. By August 5th, employers had to adopt a plan and distribute that plan to their employees within 30 days or by September 4th. Of course, by middle of September last year, the commissioner of the Department of Health designated COVID-19 as a serious pandemic that triggered the enforcement of the plan, requiring all employers to then enforce the plan that they had adopted a month previously. Now, it was not until March 17, I believe, that COVID-19 was no longer designated as such, and employers were no longer required to continue enforcement of the plan. But moving forward, it is always a good idea to adopt a plan and ensure that it is provided to every employee in case another such event occurs.
You know, also, I read that there is the possibility of workers forming panels to discuss workplace safety. Is that something new? Can you elaborate on that one?
Sure, that is also part of the New York HERO Act. Employees may form a labor management committee, and it would be comprised of both members of the management as well as the workforce. And they will essentially oversee any issues that come up with respect to the enforcement of the plan. If there is any issues with respect to complying with COVID-19 regulations, those can be brought up to the committee. The committee can then interact with the management, things of that nature. There is no requirement under the law that such committee be formed, and but however, employers are required to advise employees that they have the opportunity, as it were, to form such committees.
Just to touch briefly on what Ash was saying about having this plan, it's not just to comply with the law. It's actually, as a practical matter, it just makes sense that we won't be scrambling next time, and there is going to be a next time something happens. It can be modified and adapted for whatever circumstances are different next time. But to have the plan in place where you can just spring it out and distribute it and say, this is the plan that we have and now it's in effect, is just a good idea for employers, aside from being in compliance with the law.
I remember a lot of people talking about pivoting 2 years ago and change.
Right.
And this was the pivot, coming up with plans, coming up with ways to operate without being in the office. There was so much change that were going on. Do you believe that these changes that in the law will stay in the laws and affect employers going forward for the foreseeable future? Do you see them being rescinded is the opposite question?
Well, I'm with respect to the specific laws that we've been discussing, for example, the sick leave law, that's very specific to COVID-19.
Mhm.
And if that peters out and it becomes much less of an issue, that law may go off the books. But once there is that type of a law, it's inevitable that the next time there's some sort of issue like this, it will be then adapted towards that new issue. I think the HERO Act is more general with respect to pandemics, these types of things that arise not necessarily for COVID-19, and I think that's going to stay on the books. And I just to we didn't really touch on it, but just to go back very briefly to what we were talking about with the COVID-19 sick law and the paid sick leave, and this is talking about pivoting, where so many people are now allowing employees to work remotely or to work partially remotely from some sort of a hybrid. If an employee has to quarantine or to isolate because of COVID-19, but they are able to work remotely, the employer does not have to pay them for those days that they're out of the office during COVID-19. If they just say, well, I don't want to work during these days because it's like a nice time for me to spend with my family because I was in contact with somebody that had COVID-19. So that's something that's the law recognizes how things have changed and that many people are working remotely, and they're not going to put the onus on employers to still pay employees to not work when they could be being productive, even though they have to be home.
Okay, I need to follow that with a hypothetical, okay?
Sure.
If people working at home, I mean, I work from my home office, okay? And almost my entire staff does. And so let's say, for example, that there was a child's toy on the floor here in my house. And while I'm walking along in my house, while I'm working to get, get papers in another room, I trip over the toy and hit my head and am going to be sick for 2 days. Can I make a workers' comp claim? Because at work, if a child's toy was left by a parent who brought his kid in for the day, and I tripped over that same toy, fell on my head, I'd certainly be able to make a workers' comp claim. What about now with home workers, hybrid?
I think it's a great hypothetical. I don't see that as being a legitimate workers' comp claim, in that it's really not on the job related injury. It happens to be that they were tripped on a toy in their own home that they probably left there, or their own child left there. I can't see that. I think it remains to be seen. I would be very curious to see how the workers' comp board would treat that kind of a claim. Ash, what do you think?
I agree with you, Avrohom. I don't believe that would be a legitimate workers' comp claim, but different minds could disagree.
Well, newspaper people are good at hypotheticals and not so much always the specifics. I just wish there were child toys in my house. My kids are all grown and I would go for some of them. There was also a change to the payroll issues. Can you just briefly, Avrohom, give me a quickie overview on that? What should everybody know about pay?
Well, with respect to minimum wage, the state has been moving towards $15 an hour for everybody. And now that is the minimum wage for the metropolitan counties, not including New York City, which has been 15, but now Westchester, Long Island is also, and Rockland are also $15 an hour. And there's also a minimum for exempt employees. For salary employees, that's also been raised to a higher level than it was previously. Now, the federal level has been talked for a long time to change that. Originally, it was, I think it was Obama that proposed changing that, and that was stayed by a federal judge, and that really hasn't changed, but it's not really relevant because if you're a business that's in New York, you have to follow the New York guidelines. Wage and hour remains a huge issue. It's very easy for employers to get tripped up on the intricacies of wage and hour law, just as as an example, there's in the hospitality industry, there's something known as a tip credit, which employers can take advantage of. But if it's not done properly, then you can lose the tip credit, and you'll have been found to have underpaid your employees by $5 an hour, and you can multiply that by dozens of employees and dozens of hours and multiple years, and we're talking about serious liability. So wage and hour is always a major issue, and it's going to remain a major issue. And sometimes as the minimum wage goes up, it becomes a bigger issue.
And Ash, I'm going to ask you about another question I do want to gets through our list. There's also been a change in the law about monitoring your workers' personal contact, like in emails and such. Can you just tell me what employers should know about whether they're monitoring emails, phone calls, things like that?
Employers would essentially have to advise employees that they will be monitoring any such mode of communication, whether it is in emails or phone calls and things of that nature. As a matter of course, as long as it is a policy that the employer follows, it should be communicated in advance to the employee before enacting said policy. So as long as the employee is aware of such monitoring, that monitoring can occur.
Mm-hmm. Do you think it's a good idea to monitor your employees personally?
Depending on the industry you're in and the concerns you have, perhaps that might be a good idea.
Very good. This is the final question. We've actually gone a little over, which is fine. Okay, we've covered a great deal of ground. If there was one piece of advice that both of you would like to give to employers vis-a-vis the changes in the labor laws and other laws that have changed going forward in the hopefully post-COVID era, what would that advice be? We'll start with Avrohom.
Well, Joe, I assume you mean other than speak to your lawyer about everything that you do?
Yes, that was the in addition to your lawyer.
I think it's important to stay updated. There are so many great resources out there for employers that they can look at aside from paying a lawyer to review everything. And I think that it's always important to communicate with the employees, to have an open line of communication so that you can avoid problems. The things we touched on, like the religious issues, which are so personal in nature and can have such an effect on the morale. I think it's important that employers and employees have a dialogue and are able to speak to each other. I think that's something that's going to be a guiding principle going forward, so that there can be an amicable relationship and a productive relationship between management and employees.
Mm-hmm. And Ash, final word.
I will go back to the last point that I made. I think it is so important to communicate to the employee whatever policy it is that you wish to enforce or enact. Ensure that there is a good understanding of expectations and they're appropriately communicated. And also ensure that there is, if not an open door policy, a designated contact for the employee to reach out to with any questions that they may have. So they can continue to be compliant.
Very good. This has been a very interesting and informative session, and I learned a lot. Avrohom Gefen of Vishnik, McGovern, Malizio, LLP, Labor and Employment Law and Commercial Litigation Practices. Ash Nelyavelli, Meltzer Lippi, Labor and Employment Practice Group. Thank you very much for your expertise and time here on LIBN Now Experts Forum.
Thank you, Joe.
Thank you for having us.
And for everyone here at Long Island Business News, I'm Joe Dowd. Stay safe and good luck.
Thank you all for this valuable information. Be sure to check out our website and social media channels for upcoming webinars. Have a great day, everyone. See you next time.